This is an absolutely momentous decision. The Supreme Court has unanimously ruled that Parliament has not been prorogued. So there is nothing to stop us, members of Parliament such as myself and my colleagues, from resuming immediately the important job of scrutinising this minority Tory government as we hurtle towards Brexit. As a Scot and a Scots lawyer, I am absolutely delighted that the United Kingdom's Supreme Court has agreed with Scotland's Supreme Court that the prorogation was unlawful and therefore it is null and void. This is a huge victory for the rule of law and for democracy, and it's very much in keeping with the Scottish constitutional tradition that neither the government nor indeed the monarch are above the law.
The courts have exercised a supervisory jurisdiction over the lawfulness of acts of the government for centuries. As long ago as 1611, the court held that, quote, the king, who was then the government, hath no prerogative but that which the law of the land allows him, end quote. This court has already concluded that the Prime Minister's advice to Her Majesty was unlawful, void and of no effect. This means that the order in council to which it led was also unlawful, void and of no effect and should be quashed. This means that when the Royal Commissioners walked into the House of Lords, it was as if they had walked in with a blank sheet of paper. The prorogation was also void and of no effect. Parliament has not been prorogued. This is the unanimous judgment of all 11 justices.
At first glance, there appears to be a fundamental opposition between law and revolution, but the same people and the same events may exhibit an affinity for both notions, since every legal system must refer either explicitly or implicitly to its alegal source. Every invocation of law is, at the same time, a kind of implementation of the original revolutionary act. Somewhat less obviously, even revolutionaries may demonstrate an attachment to law, even to the law of the constitutional system they're destroying. A case in point is the English Revolution of 1688 to 89. In that revolution, King James VII and II lost his throne after an invasion force of about 15,000 men landed in England under the command of the King's Dutch nephew and son-in-law, William, Prince of Orange. William's venture was supported and joined by significant English political and military forces. James, a Roman Catholic, had made himself profoundly unpopular by his policy of tolerating and promoting the interests of Catholics, and by ignoring legal restrictions on the capacity of Catholics to hold office or to practice their religion. James fled the country, and an ad hoc convention consisting of an assembly of peers and an irregularly elected House of Commons declared that the king had abdicated and offered the crown jointly to William and his wife, Princess Mary, the daughter of King James. The political grievances against James turned on his unilateral exercises of state power. As such, the revolution marked a significant turn toward the recognition of an indispensable role for Parliament in the great decisions of the kingdom. This understanding was reflected in the promulgation of the Declaration of Rights as part of the offer of the throne to William and Mary. If there was one feature of the English Constitution to which the statesmen of that period expressed more attachment than any other, it was the principle of hereditary succession. The Whig lawyer Henry Pollexfen, William's first Attorney General and then Chief Justice of the Court of Pleas, declared in the post-revolution Parliament that all men love their monarchy, and if you make them believe that it is elective, you will catch a great many. No man ever dreamed of this. Yet the central event of the revolution was the deposing of a king who held the throne by undoubted hereditary right, and the substitution of an unprecedented joint monarchy by two members of the royal family who were second and fourth in the line of succession. No amount of obfuscation could conceal this clear act of revolution. Nevertheless, the revolutionaries of 1688 to 89 strove mightily to make their actions appear to conform with existing law. In part, this was dictated by the underlying political charges they levelled against James VII and II. His offences were largely framed as violations of the law. The Declaration of Rights announced that the king and his councillors did endeavour to subvert and extirpate the Protestant religion and the laws and liberties of the kingdom. Having justified the revolution by the illegality of the king's behaviour, they were surely uncomfortable in dwelling on the illegality of their own. Even beyond this, they were, for the most part, genuinely committed to the maintenance of legal continuity. Most of them were willing to chance the breach, but wished to do so insofar as they were able, under a cloak of legal justification. The critical central figure in this enterprise was William, Prince of Orange. By the time his fleet sailed, he was determined to settle for nothing less than the crown itself, but he was an unlikely revolutionary. Surely he was sceptical of the idea that governments must respond to the changing preferences of the population. He was a strong monarchist and attached a great importance to his own claim to a hereditary sovereignty, the tiny Principality of Orange. He premised his invasion of England in part on a right to protect his and his wife's patrimony. He had little patience with the intricacies of constitutional form. He had been repeatedly frustrated as Stadtholder of the United Provinces by the elaborate rules for consultation with and consent from the various representative institutions of the Netherlands. Once established in England, he resisted parliamentary efforts to whittle down the prerogative. He complained that the laws of England gave the king the power to destroy the nation and not to protect it. Indeed, it is generally conceded that apart from the impetus of personal ambition, William's reasons for invading England were not constitutional, but military and diplomatic. William was engaged in a lifelong conflict with Louis XIV of France. The expansion of the Sun King's empire continually threatened to devour the Netherlands. At the time of the Revolution, William was assembling a tenuous alliance of the United Provinces, Spain, the Holy Roman Empire, and certain German states. But the power of this alliance to resist France was a matter of doubt. England, ostensibly neutral, was pivotal in determining the balance of forces. Should James openly ally with France, the risk to the rest of Europe would be measurably increased. Should England adhere to the anti-French coalition, a formidable military force was possible. Whatever his real motives, however, the political circumstances of England made anything but a legal defence impossible. Of course, the brute facts of invasion and the necessarily irregular means by which the new government was established made the construction of such legal justification a challenging task. But at almost every point, the new king sought to deal with the issues confronting him in a way which could maintain at least a colourable claim to legality. Even as he bemoaned the irrational strictures of English law, he insisted a king of England must govern by law, if he hath conscience. Thus, the convention which effected the settlement was depicted as a parliament, and the installation of Queen Mary as a co-sovereign was a concession to her somewhat stronger legal claim to the crown. The new king recoiled from suggestions that he declare himself a conqueror, and his regime deviated from such legal protection as habeas corpus with the greatest reluctance. When accurate statements of the revolutionary character of the new regime were uttered, they were quickly squelched. The oaths of allegiance constructed for the new government were designed especially to soothe the conscience of its legalistic adherents. The legalist tone of the revolution and the new government was set even before the Dutch fleet set sail from Helvoetsluis. On September 30th, William published in The Hague a declaration justifying his action. This document, partly drafted by the Anglican clergyman and future Bishop of Salisbury, Gilbert Burnet, reads like a bill of indictment of the king. Over and over, William recounts the violations of law committed by James. He condemns the king's evil counsellors, who, as it was later to be stated in the Declaration of Rights, endeavoured to subvert and extirpate the Protestant religion and the laws and liberties of this kingdom. The king's dispensing with statutes is something those counsellors pretend is according to law. The decision of the Court of King's Bench, in which the king's dispensing and suspending authority was upheld, is mocked, as if it were in the power of the 12 judges to offer up the laws, rights, and liberties of the whole nation to the king. The Declaration, moreover, states William's objectives to be merely the restoration of law by the assembly of a free and legal parliament, something it claims the king's counsellors thwarted because they knew that they would then be brought to an account for all their open violations of law. The contrast the Declaration draws is between the outlawry of James II and VII and the order and regularity of the rule of law. William urged Englishmen to support him, so we may prevent all those miseries which must needs follow upon the nation's being kept under arbitrary government and slavery, and that all violences and disorders which may have overturned the whole constitution of the English government may be fully redressed in a free and legal parliament. But even if he were fully determined to act by law, it was clearly impossible to follow that course and still achieve the ends for which the descent on England was undertaken. Some of the difficulties arose immediately in connection with William's pledge to secure a legal parliament. On December 23rd, James made his second, and this time successful, flight from England. While in many ways the departure of the king simplified matters for William, it seriously complicated his plans for a new, lawful parliament. That is because under accepted law, a genuine parliament consisted of the king, the lords, and the commons. The House of Lords could meet only on a summons from the king, and the members of a House of Commons could be elected only on the king's writ. James had reputedly dropped the Great Seal of England into the Thames, in part for the purpose of frustrating any attempts to convene a parliament. A few days before his departure, he told the French ambassador that the Prince of Orange will find himself very much embarrassed what form of government to establish. The meeting of a parliament cannot be authorised without writs under the Great Seal, and they have been issued for 15 counties only. The others are burned. The Great Seal is missing. The Chancellor had placed it in my hands 8 days before I went away. They cannot make another without me. All this will create difficulties and incidents which afford me occasion to take suitable measures. That James was astute in this strategy is shown by William's reaction to a proposal formulated in 2 meetings of his supporters in Hungerford on December 8th and 9th. They suggested demanding that James recall the new writs for a parliamentary election that had been issued. William refused to assent to such a request, and would not even hear arguments supporting it. "By your favour, Sir Harry," he replied to Sir Henry Capel, "we may drive away the king, but perhaps we may not know how easily to come by a parliament." The same proposal was made in a second meeting, and the prince again objected to it. Any possibility of an authentic parliament summoned on the writs of James II was made impossible by the sabotage of the escaping king. But the effort the revolutionaries devoted to approximating such a body tells us something about the value they put on legal form. The debate on the way to secure a parliament in these circumstances took place at the outset in an ad hoc assembly of peers that had convened to take charge of the government after the first attempted escape of the king. The most obvious and most certainly legal alternative was also the most impractical. That was to call back the king, to issue genuine writs for a new election. The Earl of Nottingham suggested that the king be called back on the understanding that the new parliament would establish safeguards against future royal arbitrariness, and on the express condition that its members would be absolved from their oaths of allegiance should the king fail to cooperate. A second possible expedient anticipated the ultimate settlement by treating James' departure as a demise in law. In that event, the Princess Mary would automatically assume the throne, and she would be able to call the new Parliament into being. Finally, it was proposed to use the writs issued by King James. The king had ordered the writs destroyed, but enough survived to elect 184 members. Those legally chosen members could then provide for the election of the remainder. None of these devices was acceptable as a legal solution. The last two posed problems of legality almost as serious as those associated with a convention. The first, while impeccable as a matter of law, was a political impossibility. Consequently, it was agreed that the Prince of Orange should be asked to issue circular letters for the election of a convention. On Christmas Day, the Lords took their request to the Prince, asking as well that he take charge of the administration of the government. But he deferred responding until he had the advice of another body. On the 23rd, he had called together an assembly consisting of all the local men who had sat in the Parliament of Charles II, significantly, not the members of the compliant Parliament of James, convened in 1685. The Lord Mayor and Aldermen of London, and 50 members of the Common Council. As in the case of the irregular Assembly of Lords, William asked this group for suggestions on the way to call a free Parliament. The mock House of Commons met in the Commons Chamber on December 26th, the day after the Lords had made their address, and they acquiesced in its recommendations. These two groups that initiated the call for the convention exhibit the schizophrenic character of the revolution. On the one hand, nothing could be clearer than their non-legal character. The Lords met on their own initiative, not on a summons from the monarch. The Commons were not called by the king, and whatever past or present official status they held was in no way equivalent to that of real members of Parliament. On the other hand, they behaved very much like Houses of Parliament, electing officers, including the appointment of eminent lawyers to advise them in place of the judges, and following parliamentary procedures. William was not content with the assent of the Lords to the calling of a convention. He insisted as well on the agreement of a representative group of commoners, thus crudely mirroring a true parliamentary action. The tension between the desire to maintain some resemblance to ordinary legal form and the need to accomplish the substantive business of the revolution was also evident in the procedures employed to elect the convention. The election departed in numerous details from the standard procedure for choosing a parliament. Sustained efforts of the last two kings to remodel the constituencies so as to assure the election of members friendly to the court had made many of the local officers who would ordinarily supervise the elections untrustworthy. Consequently, William's letters to the counties were addressed not, as was usual, to the sheriffs, but to the coroners, and the letters to the boroughs, cities and cinque-ports were addressed to an ambiguously named Chief Magistrate. As the clergy were also suspect, the letters were not published in the churches, but in the market towns. Concessions were also made to the urgency of the situation by shortening the period during which the letters were to be posted. Moreover, the usual 40-day period of notice was waived to allow the convention to assemble earlier. In fact, the letters were issued on December 28th and 29th, only 2 days after the ad hoc assembly's request, and the convention met on January 22nd. These procedures, as Lois Schwerer has pointed out, reveal William's pains to preserve legal procedures. The deviations in procedure were nothing in comparison to the principal defect of the election, the fact that it was called by circular letters from the Prince of Orange and not by writs issued by the King of England under the Great Seal. It was impossible to forget that the convention could not be a parliament. Indeed, the very choice of the word convention, which was used by William and the houses themselves, betokened a recognition of the irregular character of that body. The term had already been used for some time to signify an assembly lacking the prerequisites of a legal parliament. Early in the century, it had been asserted that if the Houses of Lords and Commons met without passing a bill for royal assent, there was, in law, no session. That rule was relevant in a 1623 case in which the judges had to apply a statute that declared it would be in force until the end of the next session of Parliament. In deciding that that period would not include a meeting where no bill had been passed, the judges said such an assembly is but a convention and no Parliament or session. The same word was used regularly through the interregnum of the 1650s by those who wished to argue that Cromwell's various legislative experiments lacked the status of a genuine Parliament. The Houses of Lords and Commons that met in 1660 to effect the restoration of Charles II, like the Convention of 1689, lacked the critical legitimating authority of royal writs. Nevertheless, the members never referred to themselves as anything but a parliament. In popular usage, however, that body soon became known as a convention. One pamphlet writer in that year distinguished it as a convention lacking the right constitution of a parliament, and in response, another writer defended the parliament whom he maliciously calleth a convention. Gilbert Burnet referred to it as the new parliament, or convention as it afterwards came to be called, because it was not summoned by the king's writ. Although that 1660 convention had, as its first act, enacted a statute declaring that the Lords and Commons now sitting at Westminster in this present Parliament are the two Houses of Parliament, notwithstanding any want of the King's Majesty's writs, the doubts attaching to its status were such that it was felt necessary to pass a confirming act in the next Parliament, ratifying its actions. In contrast to the Convention Parliament's own declaratory act, however, the subsequent Parliament, which, having been called by the King, was beyond any scruple of legality, carefully avoided using the term Parliament to describe the Convention, referring only to the Lords and Commons being assembled at Westminster in the 12th year of His Majesty's reign. The illegality of the 1689 Convention is highlighted by the fact that the more radical authors of 1688 to 89 embraced the irregularity as the predicate to establishing a fundamental constitutional settlement. Such writers often positively despised the idea of a mere parliament, much preferring a genuine convention. For the men in control of events, however, this anomaly was to be minimised if not denied. The Prince of Orange had little interest in exercising any pre-legal authority to reshape the constitution. Those preferences were also revealed in his insistence on the meeting of some kind of parliament, and on his reluctance to accept the crown except on the invitation of some body that might claim constitutional licence to offer it. Shortly after his arrival in England, several of his supporters had argued for such a course, having landed in England with a large armed force, having turned back the army of his opponent, and having triumphantly made his way to the seat of government while King James fled the country. It naturally occurred to some of his supporters that the prince should simply assume power in the time-honoured way of conquerors. After King James's first departure, Henry Pollexfen, a leading Whig lawyer, told the Earl of Clarendon that William had nothing to do but in the head of his army to declare himself king. A contemporary reported that several of the greatest lawyers had urged the same course on William after his arrival in London. It was, of course, hard to deny that as a matter of brute fact, many a dynasty had originated in conquest, and English history provided no exception. But this raw reality was difficult for the legalist statesmen of the later 17th century to accept in its unvarnished form. Such scruples for legality, however, had their limits, as it became clear when the exact nature of William's accession to power became an issue. As already noted, the more legal resolution of the change in regime would have had Princess Mary ascend to the throne in her own right, and there was a small but important faction at the convention that advocated such a course. It was perhaps the neatest solution available to revolutionaries committed to maintaining at least the form of the existing constitution. It required merely the distortion of fact in connection with James' intentions in leaving the country and the birth of his son. Neither of these fictions was, in the context of that time, particularly hard to swallow. But it foundered on an insoluble problem. William of Orange let it be known that he would settle for nothing less than both the power and the title of king. It should be noted that William himself had something of a legal claim to the succession as the nephew of the king, and was in fact next in line after his wife and the Princess Anne. He had at one time believed his rights superior to theirs, on the ground that James's marriage to their mother, Anne Hyde, a commoner, should have been incapable of producing children with any claim to the throne. Only after he decided that such a claim was unsustainable in English law had he agreed to marry Princess Mary. In fact, at the time of the convention, it was argued in some pamphlets, assuming a kind of Salic law, that his position as the closest male heir gave him the right to the succession. William also might have claimed the throne as part of his wife's marital estate, but the precedents of applying this property rule of the common law to the special case of the crown were decidedly mixed. None of these arguments were really plausible, and William himself never relied on any of them in demanding or accepting the crown. Nevertheless, at a meeting with key members of the House of Lords on February 3rd, he expressed clearly his unwillingness to take any part in the English government that did not include the royal title. He would not oppose the settlement of the crown on Mary. Crowns, he told them, had no charms to him, but he would hold no power dependent upon the will of a woman. He thus confirmed what a Dutch associate had told several members of the convention some days earlier. The prince would not like to be his wife's gentleman usher. Should the convention refuse him, he would return to Holland happy in the consciousness of the services he had endeavoured, though in vain, to do for England. William's reasons for this position rested, however, on more than personal ambition or pride. He deemed it critical to secure his own position for life. Should Mary predecease him, she would be succeeded by her sister, Princess Anne, and William's influence would be at an end. His foresight in this regard was accurate, as the Queen died at the end of 1694, and William survived her for more than 7 years, during which time the military and political balance in Europe was critically changed. Given the prince's position, any hope of saving the appearance of hereditary succession by conferring the crown on Princess Mary was doomed. Revolutionaries of all constitutional persuasions agreed that the leadership of William in the new settlement was essential. Indeed, the issue was made moot when the princess sent a letter to the Earl of Danby declaring her intention to refuse the title unless William were also made king. Since by refusing to renounce her own right, Mary might also have blocked succession by her sister, this effectively removed a hereditary solution from the table. The barely plausible claim of Mary was made unavailable to the revolutionaries except in tandem with the plainly implausible claim of William. The result was the curious institution of the dual monarchy, whereby William and Mary were made joint king and queen, he a king regnant and she a queen regnant, neither merely a consort. This unprecedented and never repeated device was made workable in operation by a proviso in the offer of the throne, stipulating that the sole exercise of the regal power was to be vested in the king. While it failed to eliminate a number of practical problems, this solution nicely captures the conflicting tendencies of legal form and political necessity that characterized the revolution. Mary with a superior legal claim, representing legality, William, the indispensable political actor, representing overriding substantive necessity. Two incidents in the early years of the new government illustrate how intent it was on avoiding any taint of revolutionary lawlessness. In November 1689, Sir Joseph Tredenham reported to the House of Commons that Major General Ludlow is coming to England. The reference was to Edmund Ludlow, a veteran of the parliamentary and Commonwealth armies. He had twice commanded the English forces in Ireland. He was among the most radical of the prominent Republicans. On being asked by Cromwell what would satisfy him, he is reported to have replied, "That which we fought for, that the nation might be governed by its own consent." He was a member of the High Court of Justice that decreed the execution of Charles I, and on the Restoration had fled to exile in Switzerland. Now, in 1689, aged 72, and one of the last surviving regicides, he returned to England for the purpose, as he told the magistrates of Vevey, of strengthening the hands of our Gideon, who is miraculously raised up to deliver us from the house of bondage. In his memoirs, Ludlow indicated that he had been summoned by the new government to assist in the reduction of Ireland, and there is at least one contemporary account tending the same way. Whatever his original inclination, William's actual response to the appearance of Ludlow is consistent with a preference for the existing monarchical constitution and an unmixed hostility to the radical and regicidal strains of English political thought. In warning the Commons of Ludlow's presence, Tredenham reminded the House that they were dealing with a declared enemy to the king and kingdom. To what end do we raise taxes upon the people but to support the government? To what can these persons pretend but to bring us into the same anarchy as formerly? Now we are setting things in order. They are contriving to make us victims to their passions. I am for the public security, and it is to that end that I stand up. The Commons adopted a resolution calling on the King to apprehend Ludlow and to offer a reward for his capture. When the resolution was presented to William, he is reported to have replied that the address was so reasonable and the desire so just that he would order a proclamation to be issued out immediately for that purpose. The proclamation was published the next week, offering a reward of £200 for the apprehension of Ludlow, who stands attainted of high treason by Act of Parliament for the horrible and execrable murder of our royal grandfather, who hath presumed to come into this our kingdom, and there in privity lurketh. Before he was found, however, Ludlow escaped to Europe, where he died in Vevey in 1692. The same anxiety about any association of the new government with the constitutional experimentation of the past is illustrated by an incident taking place 2 years later in Abingdon. In his charge to the grand jury, Robert Atkins, the chief baron of the Exchequer Court, was reported to have said that the government of England was undoubtedly monarchical, but that it was not a hereditary but an elective kingdom. The source of this remarkable statement was one of the most prominent lawyers and jurists in England. A third-generation barrister, he was both son and brother to former chief barons. He had been sacked from the Court of Common Pleas by Charles II because of political differences, and had assisted in the defence of the opponents of the regime, including Lord Russell, who was executed for participation in the Rye House plot. Atkins published 2 pamphlets at the time of the Revolution. In them he expressed clearly his political philosophy. On the central constitutional issue of the Revolution, the capacity of the monarch to act in significant ways independently of the Houses of Parliament, he expressed no doubt. None but the lawmaker can dispense with the law, not he that hath but a share in the legislature. Indeed, he was later to claim that the coronation oath effectively demoted the king's authority below that of the Lords and Commons, as he was obliged by it to assent to such laws as they proposed. Naturally, Atkins welcomed the revolution. In the convention, he served as one of the peers' legal advisers, and was consulted by the new king on the best way to turn the convention into a genuine parliament. In April of 1689, William appointed him to the Exchequer Court, and it was in his judicial capacity that he addressed the grand jurors of Abingdon. His naked concession of the facts of the Revolution sent a shudder through Westminster. In July of 1689, the judges going on circuit were lectured by George Treby, the Attorney General, at the King's order to tell the people that this government has the greatest legal confirmation that it was capable of. In June, The minutes of the council meeting record a request to the Attorney-General to see what can be done to Atkins for this charge. Subsequently, Nottingham, the Secretary of State, wrote to a Mr. Edward Pocock asking for an investigation and an account of the charge, which is represented as containing matters destructive to the government and very pernicious to the peace of it. Pocock responded, confirming the subversive character of Atkins' speech. It was apparently decided, however, to let the matter rest, and Atkins remained on the bench for another 3 years. The promptness and thoroughness with which the matter was taken up, however, is a further indication of the government's determination to maintain its legal character. This attitude was manifested even on occasions when the security of the regime was thought to be at stake. During the revolution and in the early weeks of the new government, the courts had ceased to function. Some of the judges of James II had fled, and others, for obvious reasons, had been discouraged from exercising their judicial functions. Hilary term in January 1688-89 was not held, a fact which was to cause no little inconvenience. Another consequence of the cessation of judicial authority, however, may have been regarded as providential by the new regime. During this most fragile of periods, the effective by William both before and after he had become king could and did round up people and hold them without the risk of an appeal to the judiciary for their release. But with the reopening of the courts, it was to be expected that writs of habeas corpus would be sued out again. On March 1st, the king sent a message to the Parliament, noting that such detentions were essential for the security of the settlement, but also assuring them that he was unwilling to do anything but what shall be fully warranted by law. He asked for their advice as to how to deal with this dilemma. A bill was quickly proposed to allow the king to commit for 2 or 3 months such persons as he shall suspect to be obnoxious without the benefit of habeas corpus. The suspension of habeas corpus was, no doubt, a bitter remedy. The Whig and former Lord Mayor, Sir Robert Clayton, who supported it, noted that had it not been for the Habeas Corpus Act, there had not been many of us here now. We had been dead and rotten in prison. But it was mainly Tories who hesitated. Clarges advised rather that great security should be demanded for the prisoner's appearance than that the bill, the Habeas Corpus Act, should be entrenched upon, a thing so sacred. To deal with the problem by setting high bail, however, was too reminiscent of the violation of your liberties in the late King's time, and William in his message to the House had reminded it of the grievance against excessive bail in the Declaration of Rights. Others suggested that the House's advice to the King to continue to detain the disaffected would be sufficient without legislation. Moreover, when the Whig William Putney argued that a judge asked to release an applicant on a writ of habeas corpus could not very well refuse just because the House of Commons have advised the King otherwise, Heneage Finch remarked that no action at all was really necessary, since, as there are no judges yet appointed, they can have no writs, and so no necessity of bailing them immediately. The bill, however, received a first and second reading, and was committed all in one day, and when it was brought up on the 4th, all serious opposition had disappeared. Minor amendments were proposed, but the only successful one was an explicit statement that the Act should not be understood to abridge the privilege of members of Parliament. The Act, as finally passed, allowed the King or Privy Council to detain without bail or main prize any person for suspicion of high treason or treasonable practices until May the 25th. Moreover, until that day, no judge or other person shall bail or try any such person, any law or statute to the contrary notwithstanding. The suspension of judicial recourse was renewed in May and again in the autumn of 1689. This meticulous attention to and the earnest debate concerning what President Lincoln 2 centuries later, also in emergency circumstance, would call a law made in such extreme tenderness of the citizen's liberty that it practically relieves more of the guilty than of the innocent, demonstrates the solicitude of the revolutionaries for the forms of law. A final example confirms the craving for legality which characterized the revolutionary government established in 1688-89. One of the most vexing problems for the new regime was the character and extent of the oaths of support it would require. The question arose immediately upon the decision to make William and Mary King and Queen. The traditional oath called for a declaration of loyalty to the king as lawful and rightful. That was an oath many of the men who acquiesced in the revolution could never take to this king and queen. Many had justified their part in the revolution by reference to an ill-defined but venerable concept, that of the de facto monarch. Under this theory, it was permissible to adhere, at least temporarily, to an unlawful ruler who was in thorough control of affairs. But it was something else to acknowledge explicitly a legal title which they knew was false. When the Speaker of the Lords, the Marquis of Halifax, stated the refusal to impose such an oath would subvert the new monarch's title, Lord Danby wanted to know if the Lord in the chair wished to argue him into perjury. A compromise was worked out in which new oaths of loyalty would be required, but they would omit the critical references to legality. The offer of crown and declaration of rights set forth the new text. I named, do sincerely promise and swear that I will be faithful and bear true allegiance to their Majesties King William and Queen Mary, so help me God. It was significant for two omissions. No reference was made to the rightful and lawful title of the King and Queen, nor was there included a promise of continuing loyalty to their heirs and successors. This streamlined oath allowed scrupulous members of the Convention to act on the basis of the de facto theory, acknowledging a duty to authorities not sanctioned by law. In supporting the change, the Earl of Nottingham acknowledged that while William's title was not legal, a subject must now owe and expect his protection from William as king de facto. The oath, as Charles Mullett has written, was not declaratory of any title. It merely specified what the oath-taker would do. But since it only specified appropriate behaviour in a particular set of circumstances, it was an inherently flawed foundation for the new settlement. It was profoundly ambiguous as to the proper response to a reassertion of authority by the prior lawful regime, the most serious threat to the new settlement. In February, the Earl of Clarendon asked the Earl of Chesterfield whether he would subscribe to the new oaths. Chesterfield thought he should, looking upon them to signify no more than that he did swear to pay him all lawful obedience, which was nothing if ever King James came back again. For he said he was of my opinion, that he could not be absolved from his allegiance whenever he was in a capacity of paying it. As the declaration changing the oaths did not have the force of law, the issue arose again in connection with the effort of the Convention to transform itself into a parliament. By existing law, no one could sit in Parliament without taking the oaths of supremacy and allegiance to the King prescribed in statutes of 1562 and 1609, as well as satisfying the Test Act of 1678 by declaring against Catholic beliefs and practices. Naturally, no member of the Convention had taken these oaths. The statute making the Convention a Parliament dispensed with the requirements, but it did so by taking the most conservative legal approach available. After stating that the assemblies of Lords and Commons in the Convention constituted a genuine Parliament, the Act stated that the Oath and Test Acts relating to qualification of members of Parliament were hereby repealed to all intents and purposes. But as this repeal, if it were effective at all, would normally construed as prospective only, the Act went on to provide a substitute and retroactive technique for qualifying the sitting members. The members of this present Parliament were to subscribe to the Test Oath, the new oath of allegiance, the oath from the Declaration restated verbatim in the statute, and a combined and radically condensed version of the old anti-papal oaths of the reigns of Elizabeth and James I. Such actions shall be good and effectual to all intents and purposes, as if the said oaths had been taken in such a manner and at such time as by the said prior act or acts, or any of them they are required. Know verbal formulation could overcome the basic impossibility of giving this statute legal effect under the prior rules. It is instructive, however, to note the pains the drafters took to connect their actions to those prior rules. They did not merely change the rules for parliamentary qualification, they formulated new oaths, and then attempted to enact that these oaths should, in law, operate as the prior oaths, for the purposes of allowing them to make the changes.
Scotland, having entered a political union, is not currently a nation state at the United Nations in its own right, and can't currently approach international institutions as a nation state. It is open to those seeking to represent the Scottish people as a nation, which is currently incorporated in a political union with which it is no longer happy. It is open to the formation of an anti-colonial liberation movement, and a liberation movement which can be registered at the United Nations, which is not a terrifically difficult process. A liberation movement does not have to go through the colonial government. In fact, probably every single country where a liberation movement has been registered has been under some form of colonial administration. And the liberation movement has never been the colonial administration. So by definition, the Scottish government, which is a colonial administration of Scotland, would not be the liberation movement that the United Nations recognises. The liberation movement would be those people who are genuinely working for the liberation of the Scottish people. Now, you would have to start to demonstrate a level of activity, of direct action, of public support, and of perhaps undertaking certain legal actions, for example, against the UK and Scottish governments to establish your bona fides as a movement. But that's all very doable. In fact, that's exactly what those of us who believe in Scottish independence are looking to do now anyway. So I think the idea of getting representation at the United Nations initially as a liberation movement, and then using that way in to take the question of Scottish independence to a General Assembly, is a workaround. Of course, it would be better to do all these things through the Scottish government, but I'm afraid to say that it's my genuine opinion, after close and detailed study, that the Scottish government themselves are much more interested in the perks and benefits of being a colonial administration than they are actually in achieving independence. So we have to form a liberation movement against not just Westminster, but against the colonial government here in Scotland.